All over the world, the courts have played a significant role in articulating and enforcing the fundamental rights and liberties of the people. We are meeting today to discuss the role of the courts as the protectors of human rights. We have with us Justice V.M. Tarkunde, who has not only witnessed the growth of this jurisprudence, but has actively contributed to it in various capacities such as a judge, an advocate, a human rights activist and a thinker. He has been a witness to most epoch-making events of the last 70 years. He participated in the struggle for freedom, was a bitterest enemy of fascism and has been expounding humanism and philosophy of Sri M. N. Roy. We also have with us Professor Satyaranjan Sathe, who has taught law for last 4 decades and is theorizing experience and vicissitudes of human right jurisprudence. Justice Tarkunde, what role do the judiciary play in a constitutional government?
The power of the state is divided into 3 branches: the legislature, the executive and the judiciary. The judiciary has 2 broad functions. One is to settle the disputes between individuals inter se. They might have disputes of various types. The other function is to settle the disputes relating to the exercise of power by the state vis-a-vis any individual, and that power may be exercised by the judiciary or by the legislature, by the executive or by the legislature. In such a case, the judiciary has the function of deciding whether the executive has acted within the limits of law and the constitution. And as far as the action of the legislature is concerned, the judiciary has also the function to see whether the legislature has passed legislation which is within its jurisdiction, both in respect of the division of powers between the center and the states, but also in respect of the fundamental rights of the people. These are the main functions of the judiciary.
But do you think that the power of judicial review is undemocratic?
I think it is the center of democracy. How can it be undemocratic? Power of judicial review is the power to see that the constitution is properly obeyed. And therefore, when a court decides on the case vis-a-vis the exercise of power by the executive in respect of an individual, what the court does is to decide whether the rights of the individual have been violated by the executive or whether the executive has acted within its rights. You see. And so also with regard to the legislature. So judicial review is review either of executive action or of legislative action in the light of the limits of law which is imposed upon both of them.
But
Justice Tarkunde, don't you think that judicial review means an unelected court is sitting in judgment over the decisions of an elected legislature?
Yes, but the court is not elected, but a good deal of care is taken in the appointment of the judiciary. As far as the lower judiciary is concerned, the Public Service Commission is the main authority with the assistance of one judge of the High Court in making appointments of judges who become either the subordinate judges or district judges. Then as far as High Court is concerned, the present position is that the Supreme Court, Chief Justice and two senior most judges, they decide who should be appointed in consultation with the Chief Justice, in consultation with the Chief Minister in the case of a High Court judge, in consultation with the Chief Justice. Chief Justice is already there, but in consultation with others also as far as the appointment of the judge of the Supreme Court is concerned. Mistakes are committed, but this way in which judges are selected is generally a better way than election of judges, which is followed in America in some respects.
But how then do you think, Professor Sathe, that the judiciary is accountable, and to whom it is accountable? Can you respond to this?
It's of course accountable to the people in the ultimate terms, but I would like to hear Justice Tarkunde on this.
You see, accountability depends to some extent on transparency of the functioning of the judiciary. One principle which has been laid down and is laid down for this very purpose, that all trials, except some few exceptions, all trials must be public and should not be in camera, so that the public can see whether justice is done or not. To see. The second thing is that if a final decision is given judicially and if that decision is not appreciated, every person has the right to criticize that decision publicly, except that motive should not be attributed to the judge. Judge, if he commits a mistake, you can say that he has committed a mistake. Judgments have been condemned. Now, the judgment which was given in the habeas corpus case, see, that judgment was condemned as an infamous judgment, publicly condemned as an infamous judgment, and they could not take any objection to it. You see. That is the second thing. But I am of the view that there are some aspects of judicial work which are not transparent, and there are some areas where judicial accountability is required to be further strengthened. One is that we have found that recently judges of the High Court, some judges, I think they are exceptional, but they are not above corruption. Corruption in the form of nepotism, corruption in the form of even acceptance of some consideration. Now, in such cases, the remedy of impeachment is very cumbrous, and therefore it is proper to suggest, we have suggested, means there is a committee for judicial accountability functioning in the Supreme Court, entirely non-official, of which I am one of the members. And we have prepared a bill for the purpose of having a high power judicial committee consisting of recently retired judges of the Supreme Court and some very eminent recently retired judges, Chief Justices of High Courts. That committee should have the right of examining complaints against High Court judges and Supreme Court judges, both with regard to misbehavior, alleged misbehavior, or with regard to any degree of acceptance of impartiality, in any case of partiality and so forth, you see, or even case of what we call bribing and bribe taking and other things. So I think such a committee will be useful, even in respect, or even for instance, in regard to appointment of judges to the High Courts. Things have happened in the past where persons who are entirely undeserving have been appointed High Court judges. Why should it not be possible to file a petition in the Supreme Court saying that those judges, the appointment appears prima facie to be partial, a result of partiality and discrimination. Other people were available who were much better, and therefore this matter should be investigated, publicly investigated. I think that power ought to be exercised. Therefore, I am of the view that apart from, though I respect the independence of the judiciary, I don't go to the extent of saying that no further steps for increasing the accountability of judges should be taken. In my opinion, such steps should be taken.
Well, what is judicial activism? Probably the topic of current importance. Do you think that the judiciary has encroached on the powers of other wings of the state?
There is a lot of misunderstanding about the word judicial activism, and in some cases it is used in a disparaging way. You see. Judicial activism is the very basis of judicial work in a large number of cases. The entire common law of England is an instance of the development of judicial activism functioning on a broad basis. In England, to start with, there was hardly any law. Law means law laid down by Parliament with regard to many topics. The whole whole law of contracts, whole law of torts, even the law of evidence, that has been developed by decisions of judges from time to time. But what the judges did was that they said, all right, there is no parliamentary law on the point, but justice has to be done. This is, in our opinion, a just cause, and then they declared that this has been the traditional law of England. So they did not purport to make law. They merely declared what the law was. But actually what happened was that they made the law. But while making the law, they also considered the previous precedents. And by precedent to precedent, common law has grown in England. That's a judicial activism. And that has got to be done. Now, in the present day society, what we find is society changing very fast. New problems have coming up, new problems of pollution, new problems of various types will come, you see. And on every problem, you will not find that there is a law. What are the judges to do? They have got to exercise their authority to see that justice is done. They must look to what the legal provisions are, what the precedents are, and if the precedents are not sufficient, they must lay down a precedent. That is judicial activism.
And moreover, whenever a court is interpreting a written constitution, it is bound to be an activist court, according to me. Judicial activism is inevitable in a system where courts are interpreting the constitution.
So I would rather say, modify Dr. Sathe's statement by saying that judicial activism ought to be there. I know judges who do not have it, you see. I mean, I know judges who are not sufficiently bold to come forward and say, all right, this is the law. They will try to, I mean, it has resulted in injustice in many cases. There are judges who are bold and who have got the confidence that what they say is correct. There are judges who are diffident. So it is confident judges who make good laws.
In fact, the judges have empowered the people by expanding their fundamental rights, given them new meanings from time to time. So that has been the major contribution of judicial
Well, will you please
activism.
highlight on that how the Indian Supreme Court has protected the human rights of Indian people?
They have, you see, particularly Article 14, right to equality and right to personal liberty. These two articles have been given new interpretations, and thereby many new rights have been recognized as being part of those rights. And that is why I said they have empowered the people. Now, this empowerment of the people is a very important contribution of the Indian Supreme Court.
I will add one thing to it. It's perfectly right in saying that Article 14, its scope has been expanded. Formerly, Article 14 merely meant, according to the Supreme Court, non-discrimination. But Supreme Court went further and said that every arbitrary act of the executive is violation of Article 14. It need not be merely discriminatory. If it is arbitrary, irrational, without any foundation in justice, then it is a violation of Article 14, because it says there must be equality of all citizens must be equal before the court. They have equal rights. Now, they have no rights if the law is not enforced. So, enforcement of law is itself a principle of Article 14. That's how the Supreme Court went. In Article 21, they decided that it says that no person can be deprived of liberty or life or liberty without without a procedure established by law. Formerly it was held by a bench of 7 judges, 5 against 2, that any law, provided it is within the constitution, any law is enough for the purpose of depriving a person of life or liberty. Supreme Court ultimately held, reversing the earlier decision. They held that the law, the procedure established by law, means that the law must be a just and a just law and a rational. Justice and rationality must be satisfied by the law if the liberty of the person is invaded. They also interpreted life as not merely animal life, but life of human dignity. So that's why they have, but apart from these two factors, which Dr. Sathe has mentioned, there is a third factor which has greatly increased the functioning of both the High Courts and the Supreme Court, and that is the principle of locus standi, which resulted in public interest litigation.
Yeah.
Formerly the law was that a person who was personally aggrieved, himself aggrieved, by any particular action, executive or legal, he alone could go and file a litigation. Then it was held first in England and America that this is not the correct position. Any person who is not a busybody but is interested genuinely in social justice can act on behalf of persons who are normally not able to approach the court. And in India, that is an enormous area, much more than in England and America. Large parts of the people, agriculturists, workers and poor people generally, they can't go to court.
Yes.
On their behalf, persons interested can file petitions. And this extension of the jurisdiction of the High Courts and the Supreme Court is the main cause of main reason why the High Court and the Supreme Court is now able to do justice much more effectively than it did in the past.
And I think particularly to the weaker sections of the society.
That is, that's what it is meant for.
Yeah.
Public interest litigation is meant for them.
Most of the disadvantaged sections of society
Yeah.
have come to the court in recent last 2 decades.
Yeah.
Bonded laborers, prison inmates, under trial prisoners,
Yeah.
child labor,
That's
all these interests have come to the Supreme Court.
I think an independent judiciary is the backbone of democracy, as is being discussed just now. I thank both the speakers for having spared their valuable time and given us valuable information and insights of the subject of great importance. Thank you.
Thank you very much.